Thank you, Mr. Chairman, and thank you, Judge Jackson, for joining us today. I appreciated the conversation you and I had in my office a few days ago, and your willingness to engage in a lively, interesting conversation during that. I look forward to more of that this week. I've enjoyed also meeting your husband and your two lovely daughters. They're wonderful people. I'm grateful to you for your service to the federal judiciary and as a member of the bar. You bring to the court, as I mentioned to you last week, a unique set of experiences. If you're confirmed, you will be someone who has served at all three levels of the federal judiciary. And as a result of that, you'll have a perspective that's different than that of most who have served on that court during the modern era. And I appreciate your willingness to be considered and to be here to talk to us about our questions. I echo what many of my colleagues have said today, in that I am dedicated, as I always have been, to making sure that these hearings are respectful. Engaging in the politics of personal destruction is not something we should ever aspire to. It is something that has occurred on this committee in the context of Supreme Court nominations. I'm pleased to say that it has never been under Republican leadership that such attacks have occurred, and I intend to make sure that this hearing is no exception to that. There are a few reasons for that. First and foremost, the most obvious, is that respect to human beings requires it. Secondly, it's important because if we focus on personal attacks, that means we will be betraying our duty under the Constitution and to our constituents to make sure that we do our jobs fairly and properly. When we're focused on things that we have no business doing, like bringing forward spurious, last-minute, uncorroborated accusations of a personal nature, we neglect the importance of talking about the jurisprudential role, the philosophy that guides individual jurists, and the document that we're all sworn to uphold and protect, the Constitution of the United States. It's also important for an additional reason, a third reason. It has to do with the fact that, having been nominated to this position, we know that you stand a very decent likelihood of ultimately being confirmed to this position, in which case you'll serve as a member of the Supreme Court of the United States. And I think it's important that even when, especially when, we disagree with decisions issued by that tribunal, we as a committee, as the Senate Judiciary Committee, not engage in speech or behavior that would undermine the legitimacy of the Supreme Court of the United States. You see, it's the legitimacy of the courts that gives them their potence, their power, their significance in our system of government. We all have a duty to make sure that we don't undermine that very thing that we purport to be protecting. Let me tell you some of the things that I look for when reviewing a nominee, and a few things that I intend to focus on in these hearings with you. One of them will involve any nominee's commitment to judicial self-restraint, to understanding the judicial role, what it is and what it is not. Any judicial nominee these days will acknowledge that he or she understands that the role of the judge is to interpret the law based on what it says, rather than on the basis of the judge's personal opinion. This is all very true. It raises questions as to how exactly that goes about and what steps, what tools, what rhetorical, linguistic devices the jurist in question might follow in order to do that. I'm looking for someone who is ideally going to echo something that Justice Amy Coney Barrett said in her confirmation proceedings, in which she likened the Constitution, this document written by wise men nearly 2.5 centuries ago, wise men who I believe were raised up by Almighty God to that very purpose. To the extent we follow that document, it's helped foster the development of the greatest civilization the world has ever known. But she likened this and our commitment to it as a little like what Odysseus told his crew. She said the Constitution is like how Odysseus ties himself to the mast to resist the song of the sirens. She then goes on to explain that he told the crew, "Do not untie me, no matter how much I beg or plead, don't untie me from the mast." He wanted to avoid the tempting call of the sirens. The tempting call of the sirens is inherent. It's in government itself. It's understandable, and that's why we tie ourselves to it. Critical to that is the federal judiciary, the ultimate backstop, the backstop that's there to resolve disputes. Now, the Constitution isn't just something for the courts. It's not something that's owned exclusively and independently by the federal judiciary or the Supreme Court itself. But it does play an important role because the court's there to resolve disputes that arise within the court's jurisdiction as to the meaning of a particular provision of federal law, whether in the Constitution itself or as enacted into law by Congress. So we need a jurist who's willing to respect that role and demonstrate judicial humility. What I mean by that is an ability to acknowledge that there are a lot of things not within the province of the courts that entail policy. The job of the court of the judiciary is never to exert will or force. It is only judgment. It's discerning what the law says. A nominee also, I believe, needs to show a steadfast commitment to the principle of separation of powers. There are a couple of forms of separation of powers required by the Constitution along two axes. One operates along the vertical axis that we call federalism. It says most of the power of government within the United States, most powers that government might exercise are to be exercised at the state and local level. Power that's federal is the exception, not the norm in our constitutional system of government. The other form of separation of powers operates along the horizontal axis. It's one that recognizes within the federal government, which is limited, we're going to have one branch, our branch, Congress, that makes the laws. Another branch headed by the president, the executive branch, that enforces them. And the third branch, which interprets them, resolving disputes between parties coming before the court's jurisdiction. Third, I think it's important that a jurist within our system of government acknowledge the importance of interpreting the law as it was written, as it was understood by the public at the time of its enactment, if a statute or if a provision of the Constitution at the time of its ratification. This is part of how we tie ourselves to the mast, making sure that we undertake efforts to make sure that we're interpreting it based on how the public understood those words, regardless of the subjective intent of any particular lawmaker or group thereof. The public meaning at the time it became law. This is how we maintain the rule of law. This is part of how we've given force to this greatest civilization that human history has ever recorded. It's through the rule of law and tying ourselves to that mast. There are increasing threats to this. We've seen those threats arise with efforts to delegitimize the court, and I'm sickened every time I see or hear or experience one of those efforts to delegitimize it. We've heard some today, in fact, comments that I think by their very nature delegitimize the court. Another thing that can delegitimize the court are arguments made in favor of packing the Supreme Court. This was attempted by President Franklin D. Roosevelt in 1937. It did lasting damage to the court. It didn't succeed as a legislative matter. But it's arguable that it left a mark and not a pretty one. There is nothing in the Constitution that requires us to have 9 and only 9 justices. That is, under the Constitution, left to Congress's determination. But 9 is a number that works. It's worked now for 152 years. It's not one that we ought to revisit, and it's one that Supreme Court justices of various ideologies, including your former boss, Justice Breyer, whom I really enjoyed getting to know when serving as a law clerk on the Supreme Court. I enjoyed our conversations with him. He, Justice Ginsburg, Justice Thomas, and so many others have been against that. We must protect the court. We may not protect the court. We lose ability to protect the court if we allow arguments to take root that are focused on expanding that and turning the court into a political body. Thank you, Mr. Chair.
Thanks, Senator Lee.